So everyone should be able to see just the screen now. So we've kind of already done the introduction. And I know we did some land acknowledgements, but I also just wanted to acknowledge that here in Kamloops, I am on the unceded territory of the Secwepemc Nation.
And I am in my home in Vancouver on the unceded territory of the Musqueam, Tsleil-Waututh, and Squamish peoples.
And we just wanted to do a quick disclaimer here. This presentation is meant to be a practical introduction for advocates to, there's some very complex legal issues and is not intended to be comprehensive. If you have any doubt, I always recommend that you talk to your supervising lawyer.
Yeah, I agree. And I will just pick up on that and say that, I mean, I think you're going to hear us say a lot of the times today, in many cases, the most helpful thing you can do if you have a client who's facing a human rights issue is to try to help them get legal advice. And you might be able to consult with your supervising lawyer, but sometimes it's better to try to find independent legal advice for your client if it looks like that's necessary.
And this is just a quick overview of what we will learn today. So we're going to go over the human rights law, the legal process, and which venues you may want to choose, some practical considerations, and then we're going to go through some scenarios which will involve some breakout sessions.
So I'll talk about what is human rights law. As we said here, we're just going to introduce some basic concepts. We might be leaving out other important concepts, but as we said before, this is supposed to be an introduction to some potentially complex areas of law. So the British Columbia has a human rights code that helps protect people against discrimination and harassment. The Human Rights Tribunal is responsible for hearing complaints under BC's Human Rights Code. And the code targets discrimination and attempts to prevent discrimination based on what are called prohibited grounds. In a later slide, we're going to refer to some other tribunals or other human rights bodies where human rights issues can be addressed. Every province has some version of BC's human rights code, but each provincial law is somewhat different. And we're going to focus on the BC Human Rights Code, but we'll also talk a little bit about the Canadian Human Rights Act, which applies throughout Canada, but only in areas where the federal government has jurisdiction. So we'll be discussing that in a little more detail in a few more minutes.
And I know there's a session this afternoon that will go over these a little bit more, but these are the prohibited grounds that you're going to come across when that are under the code and that allows you to make a human rights claim. Just to point out a few of them, so we have race, color, and ancestry and place of origin. Those can be very connected. They can also be very separate, and it's just something to be aware of. One of the things I wanted to point out that I actually had on a file was discrimination based on color, and the answer was from the other side was, well, we actually hired a person of color. And so when they were trying to do an application dismiss, which you'll learn about in the other session, but what was interesting on that is I actually had to file a response to that explaining that even within, that prohibited ground, color, you can have discrimination based on color, even though you've hired another person of color. And it was quite surprising that I had to explain that to the law firm, but color, there's colorism, right? There can be different, you could be discriminating even on race and ancestry or place of origin. All those things, it doesn't have to be so direct. You can have situations where a person of color is discriminating against another person of color. We know that there's, this scenarios where the more light-skinned you are, and sometimes you can get more favorism. So just to be kind of aware of that even though it doesn't appear on the face of it. Of course, then you have age. A lot of discrimination when it comes to age is actually more on the senior end of the spectrum. It can be all across, but generally when you see age, it's usually somebody who's getting closer to retirement, and you're going to see that. Then we have your sexual orientation, and that includes gender as well. So sexual orientation and sexual gender, that's, proper use of pronouns and different scenarios like that. We just had a really good case come out about using proper pronouns. and how that can be based in discrimination. Then you have your religion and your family status. Family status, I mean, religion's pretty self-explanatory. Family status, it can be all kinds of, whether you're married or you're single. Physical disability and, sorry, I realize it's missing off here, mental disability. So both of those are also ways. And then there's also political belief. So of course, if you're on different political spectrums, you couldn't let someone go just because they had a different political belief than you. Marital status, and then source of income. And I kind of just want to point out that one in particular. That's generally in a rental scenario where someone who has a source of income, so you can't deny someone a rental just because they might be on income assistant or person with disability, any of that kind of, you can't deny them renting to them based on where their income is coming from. And then if you notice there's a conviction of criminal summary conviction, that's only in an employment scenario. So really what that's saying is if you are hiring someone, you can't discriminate against them just because they have some kind of past criminal conviction, unless it relates to the job, right? So of course, if you've been convicted of, crimes against children, you wouldn't then, you wouldn't be required to hire somebody who's dealing with children. So it is connected more to the employment. So that's the only one that kind of has that extra little caveat there.
Yeah, and I will pick up on that. I mean, I agree with what Odette is saying, that some of these grounds only apply in certain situations. I was looking at the code last night, and I think political belief is another one of those. So as Odette said, for example, an employer cannot fire you because of your political belief, but it's not a prohibited ground in relation to a tenancy. So in theory, at least, a landlord might be allowed to refuse to rent to someone because they don't like their political beliefs, or because the person has a conviction for a criminal offense. Everything is usually going to depend on the specific language of the law that we're talking about. In this case, it's the BC Human Rights Code, but for example, if we're talking about something under federal jurisdiction, the Canadian Human Rights Act has somewhat different rules. Everything just depends on the specific wording of the law that's at issue. Next, we're going to talk about some of the areas to which human rights laws apply. Human rights law and prevention, the prohibition on discrimination, it doesn't apply to every single interaction between people. It applies only in specific types of relationship. For example, as it says here, in employment relationships, human rights laws can be important at the time of being hired and also potentially when you're being fired. Human rights laws allow people to seek accommodation and to ask, in some cases, for individualized or special treatment on the job or at the workplace. Human rights laws also apply to housing and property, and that can mean any number of things related to housing, including the ability to buy and sell property, to own property, but also what probably you might, as advocates, you might be more likely to see situations where human rights laws come up in relation to residential tenancies. Laws also apply to ads for housing or ads for rental tenancies. So you can't, for example, say that you're only willing to rent a place to people of a certain religion or people of a certain racial background. Would obviously not be okay. And human rights laws also apply to what's called services in the law, and that can be a very broad category. It can include government services, for example, education and healthcare, but also other types of government services, such as policing services. It can also apply to services in the private sector. For example, almost any time you're dealing with a store or a private business, that private business is not allowed to discriminate against customers or against anyone else based on the prohibited grounds that we were going through a minute ago. Human rights laws wouldn't apply, for example, to private interactions, like private conversations between people, unless those individuals have the same landlord or the same employer, or one of them is involved in the conversation or the interaction as part of their job. So it's important to keep in mind that human rights laws don't prevent or don't even attempt to prevent all forms of discrimination, but only specific types of conduct that's specified in those laws in specific areas of life, as we've discussed here, like employment and housing and the delivery of services.
So just an example of that is if your neighbor, is yelling racist comments at you, that would not be covered underneath the human rights code. That wouldn't be something where this human rights law would apply, unless, as Andrew was saying, you had the same landlord, and then it would be going through your landlord to deal with that.
Yeah, in the sense that your landlord would have a responsibility to make sure that, or to at least to take steps to ensure that you're free of discrimination, that you don't face discrimination in your home. But if we're talking about, let's say, two houses right next to each other, and the neighbors are yelling nasty things to each other over the fence, probably human rights laws would not have anything to say about that situation, even though it's obviously an unfortunate, ugly situation.
So then just to, we've kind of alluded to this, that there's really two kind of laws in BC that apply. So you have your federal jurisdiction, you have your provincial jurisdiction. So in your federal jurisdiction, you have the Canadian Human Rights Act, and just shortened down CHRA. And then you have your provincial jurisdiction, which is your BC Human Rights Code. And that's the Human Rights Code then would go to the Human Rights Tribunal. And there's actually a different commission and tribunal for the federal jurisdiction. And just important thing to kind of always be aware of. As lawyers, we're very aware of the difference between federal and provincial jurisdiction. It's something we're very trained in. But a lot of clients and maybe yourself as an advocate, it doesn't come necessarily as instinctual to realize that there's that difference between the jurisdictions. I mean, you could even see it in the past election when people were talking about vaccine passports, which is a provincial issue, not a federal issue, even though it was a federal election. So it's kind of a hard thing for people to kind of grasp their minds around it, that it's not something that, you need to make sure, and we're going to go in further, how you would tell the difference, which one to go into, but just be aware that one of the first things you're always going to do is look at the situation and figure out, is this underneath federal jurisdiction or is this underneath provincial jurisdiction?
Right, so in this slide, we have some examples of some areas that are under federal jurisdiction in Canada. And so this is not a comprehensive list, but this probably covers most of the federal jurisdiction areas that you might come across as an advocate in your work, including banking, airlines, interprovincial travel, telecommunications, which includes the internet, and that would include most messages posted on the internet, for example. The fisheries come under federal jurisdiction, federal department or agency. So for example, the RCMP, or if you're dealing with an Office of Service Canada, for example, if it's an agency like that that's operated by the federal government, then it is almost certainly under the federal government's jurisdiction. The other thing listed here is First Nations governance. And one thing I want to highlight in relation to that, which I learned the hard way from a case that I was involved in some time ago, is that it's very difficult to say for sure what level of government has jurisdiction over employment by government organizations on reserve. For example, if a person works for a First Nation itself, or a band office, for example, it's not easy to determine whether they are under the jurisdiction of the federal government or the provincial government. And in some way, I think this is an example of the difficulties created by imposing the Canadian legal system on Indigenous people. It just gets very technical to determine whether a person employed by a band or a nation's government, if they face discrimination, does the BC Human Rights Code apply, or does the Canadian Human Rights Act apply? In other words, do you complain to the BC Human Rights Tribunal, or, as we'll hear about in a few minutes, the Canadian Human Rights Commission? So this is one of those situations where I would say, if you're ever faced with someone who is concerned about discrimination on the job, and they work for any kind of First Nations governance organization, especially if it's on reserve, that is a situation where I would urge you to try to help them get legal advice, help them to talk to a lawyer to try to make sure that if they do need to file a complaint or seek some kind of remedy for that, that they're going to the right place, that they're going to the right level of government to try to seek whatever remedy it is that is appropriate in the situation.
And it is tending to lean more towards provincial jurisdiction than it is federal in the law. They, when it comes to employment, they seem to be favoring things going more toward, I don't know in the human rights, I just know in employment. They're tending to lean it more towards the provincial, but yeah, it's quite the test to figure it out. So then underneath kind of the provincial jurisdiction, you're going to see healthcare, you're going to see education, that housing, unless, I mean, I'm trying to think of a situation, maybe if there was a federal housing, but housing is almost always going to be under provincial. Services and facilities to public. So when you're going to those restaurants, you're in those stores, that's going to be provincial. Most workplaces will be provincial. That's, again, you need to kind of keep your eye on that, making sure that it is provincial. And almost everything else that the federal does not do, that's going to fall underneath that provincial jurisdiction.
Yeah, as it says here, I would just pick up, as it says here, almost any services and facilities available to the public are under provincial jurisdiction. The only exception I can think of is if they're operated by the federal government. So example, what's coming to mind for me is for example, Service Canada offices or a national parks office, for example. I see someone in the chat is mentioning housing and other issues that come up on military bases. Thank you for that, Jen. I agree with that. That, I mean, if an issue is arising on a military base, that is almost certainly going to come under the federal jurisdiction as well.
It's a similar, and I mean, Andrew, you correct me if I'm wrong on this, but if you were, we're talking about the RCMP, which is federal, but if it was the Vancouver police force, then that's going to be provincial. So you just need to kind of be aware of that. Who is, kind of in charge of whatever that service is, right? So the RCMP is federally regulated. It's a federal organization, where the Vancouver is a municipal organization. So that is a provincial police force. So it's not so like, oh, every police force is going to be federal or provincial. You really kind of have to look at, knowing who's kind of in charge of those organizations.
And I saw there was a question in the chat from Joyce, who was asking if the Canadian Human Rights Commission can help figure out whether a matter is under provincial or federal law. And I think what I would say to that is, we're going to talk about the Canadian Human Rights Commission in a few minutes. I would say there's probably no harm in calling them and asking for that, but it's not the Canadian Human Rights Commission's job to provide legal advice in a situation like that. If it's a pretty simple case, they might be able to tell you, yeah, we hear complaints about, the bank all the time, or about the Mounties, for example. They're going to be able to tell you, yes, that's something we deal with. But if it gets more complicated than that, this is a situation where I would still advise someone they should probably talk to an independent lawyer rather than a government agency like the Human Rights Commission. The Human Rights Commission, frankly, would probably give them the right information in that situation, but I'm not sure that's officially within the Human Rights Commission's mandate, and so I would still be telling them to talk to a lawyer if that's at all possible before they decide how to proceed with a complaint or a claim.
And just realize, because the timelines on these are so short, like in BC, it's that year that you have to make that complaint, that you really want to be careful to make sure you get it underneath the right one, because they may not respond to you. I have things that I filed back in November that I haven't heard anything about. So things are really backed up right now. I do have another one where it was a single incident that involved both provincial and federal jurisdiction. And so we had filed it provincially, and then they wrote back to us and they're like, well, we're not sure this is completely provincial. It might be federal. So we actually filed it in federal as well. So we kind of have two going right now, which isn't what I would recommend, but it's, I can't get into the facts. It's a really weird situation. So it kind of, you wouldn't normally do that. And then the Canadian, Human Rights Commission wrote and said, well, this could be a provincial issue. So we've kind of covered our bases on that. Normally you wouldn't do that, but it's kind of a weird situation where both of them aren't quite sure which one it should be in. So just even the different, human rights organizations don't always know clear cut which one it should be underneath, but that won't normally happen. Just don't rely on them. That's my thing. You can always call them up and try to get that information, but because the timelines are so short, and it doesn't seem like a year doesn't seem that short, but by the time your client's coming in, you get that information, you get it drafted up. It really is a short period of time. And if you have it waiting in line, you might have filed it, with the BC, Human Rights Tribunal, you might have filed that complaint. But if they don't get back to you in time and that timeline passes, just because you filed it in BC, you're hooped. The Canadian's not going to accept it, right? I mean, you might be able to make an argument for it, but the timeline doesn't stop just because you picked the wrong jurisdiction. That's kind of what I just wanted you to be aware of there.
Okay, next we're going to talk a little bit about the differences between human rights tribunals and commissions, and how that depends on what level of government we're talking about. In other words, there's a difference between the relationship between the tribunal and the commission in BC versus the relationship between the tribunal and the commission in Canada at the federal level. Here in BC, and I think this is true of the Canadian Human Rights Tribunal as well, but the tribunal is an impartial body that makes binding decisions about allegations of violations of human rights. And the tribunal does have the power, if they find that there has been discrimination, the BC Human Rights Tribunal has the power to force people or organizations who violate the Human Rights Code to take steps to improve their practices, to prevent the violation from happening again. And the tribunal can also force an organization or a person who's violated the Human Rights Code to pay compensation to a complainant or to someone else, or to someone who's been affected by the discrimination, among other remedies. The Human Rights Tribunal is mainly a decision-making body, sort of like a court, but of course they can only deal with human rights cases. They do not. I think this is a common misunderstanding that I hear about. The BC Human Rights Tribunal does not investigate complaints. It is up to the person who makes the complaint to provide evidence that proves their allegations, that proves that what they say happened really happened, and to explain why that counts as discrimination. But as I said, if the BC Human Rights Tribunal sees that evidence and finds that there has been a violation of the Human Rights Code, they can compel the respondent, the person who has violated, the person or organization who has violated the Human Rights Code, to change its practices or pay compensation, or as it says here, to provide various other types of remedies. So that is the role of the tribunal here in BC.
So then we're going to look at the Human Rights Commission here in BC. So in BC, the Human Rights Commission, they don't play a role in the tribunal process. So they are not the ones that's furthering your complaint. They do not act on individual complaints. Their role is to promote education and research about human rights. So, I mean, you could reach out to them. They may give you some information around issues if you ask them questions about which jurisdiction, but really they're here to promote education, do some research around human rights, and they also advocate at a systemic level. So they are the organization that's going to really be dealing with some of those systematic issues within British Columbia, which is different than kind of the role on the Human Rights Tribunal, which is acting more as, more as a decision-making body.
Now I'll talk about the Canadian Human Rights Tribunal. That is the tribunal that applies at the federal level to issues that are under the federal government's jurisdiction. Like the BC Tribunal, the Canadian Human Rights Tribunal can make binding decisions about human rights and can force people or organizations who violate human rights to take steps to improve their practices. But one major difference between the BC system and the federal system that applies to the Canadian Human Rights Tribunal is that the Canadian Human Rights Commission must approve a complaint before it can get to the Canadian Human Rights Tribunal. So once again, the tribunal itself is sort of like a court in that they are independent and impartial, and they have the power to compel respondents to change their practices or pay compensation. But in order to have your case heard at the Canadian Human Rights Tribunal, you must first go through the Canadian Human Rights Commission. When you initially make your complaint, if you're complaining about an issue that's within the federal government's jurisdiction, you first go to the commission, and they screen your complaint to decide whether it will go to the Canadian Human Rights Tribunal.
That's kind of, what Andrew said there. The Commission also promotes education and research about human rights and advocates on a systemic level as well, right? So the Human Rights Commission, they're investigating those individual allegations about human rights violations, but they're also doing similar to the BC Human Rights Commission, where they're promoting the education, doing that research about human rights, and then stepping in on a systemic level to try to make some of those overarching changes within our society.
And I want to add something to this slide. I wanted to add that unlike the BC Human Rights Tribunal or BC's Office of the Human Rights Commissioner, the Canadian Human Rights Commission actually does do its own investigation into individual cases. If you make a complaint to the Canadian Human Rights Commission as part of their screening process, as part of deciding whether it's going to go to the tribunal, an officer of the Human Rights Commission will actually look into your case and potentially interview witnesses, review relevant documents. And it's after doing that investigation that a decision is made about whether it should go to the tribunal, whether your complaint should go to a tribunal for a hearing. If the commission decides that it does not merit a hearing, then that's generally the end of the process. You can't decide on your own to go ahead to the tribunal and get a decision. There are ways to challenge or to appeal Canadian Human Rights Commission's decisions, but unless you appeal their decision, if they decide that it's not going to a hearing, then that is the end of the Canadian Human Rights Tribunal process. If the commission finds that there should be a hearing, then they forward the case to the Canadian Human Rights Tribunal, and from there, the process looks a lot more like, for example, the BC Human Rights Tribunal process, where it's just an independent decision maker hearing both sides and giving each side a chance to make their allegations and test the other side's case before the tribunal makes a final decision.
So then what other venues might you be going underneath? So we have our, we were talking about this, all of you advocates should be very familiar with this, but you have your residential tenancies. So here in BC, that's going to be the residential tenancy branch. The residential tenancy branch is not going to make decisions on human rights issues. You have to realize that you're not going to be able to make a complaint to the the residential tenancy branch about a human rights issue. Now, they may make a ruling on that, there's the disturbance of other tenants, if we have that scenario where they're, the tenant is being a real jerk and saying lots of really bad things to another tenant, they may make a ruling that other tenant can be evicted because of the things that they're doing to one of the tenants or to the landlord. Like if a tenant was being or the landlord the other way, they can make some decisions about that, but they're not actually going to make a human rights decision, right? It's a little bit different. They're not going to make a decision around those prohibited grounds. It's going to be based on, that right to enjoyment of your tenancy, that disturbance issue. So it's a completely different kind of decision than you would receive in the human rights. Then you also have your provincial and federal courts. They're going to consider your kind of employment issues, but they're not going to deal with the same kind of human rights issues as you would get into the human rights. It doesn't mean that they wouldn't make comments around it, but it's a little bit of a different venue. You're going to get different kind of remedies. You're not going to get from the Supreme Court or small claims or the Civil Resolution Tribunal, you're not going to get a decision that says, they have to take some kind of education. They're going to force an employer is going to be forced to kind of educate the employees around those kind of human rights issues. So once again, it's a little bit of a different process there. Then you kind of have your other arbitrations. And I mean, this isn't an extensive list. These are just some of the main other venues that you may choose to go underneath. And then those grievances ones, you're going to have unions. So of course, whenever clients coming to you and they're talking about unions, you need to make sure they're going through their union first. There's a grievance process in there. They need to be following those collective agreements. You know, a lot of times clients kind of want to bypass that, or they don't like what the union's saying. So you need to be aware that you know, the collective agreements there for a reason, the union's there for a reason, and they need to go through that process first. Once again, going through that process is different than the human rights, right? So it's a different venue than the Human Rights Tribunal. A union is not going to make the same decision. Yes, that's a human rights violation, and these are the same remedies. That's not how it works. It's different remedies. Same with workers' compensation. So just you need to be aware that there's those other venues that are going to handle different issues, right? Just like the Human Rights Tribunal is not going to say they might say that they, you know, shouldn't have been dismissed, you know, that they were dismissed based on discriminatory things, but they're not going to actually say they were wrongfully dismissed, because a Human Rights Tribunal can decide that the employer had a reason to let an employee go, right? They can say, yep, they had it. But part of the basis of letting them go wasn't only all these other things they did, but was partially based on a human rights prohibited reason. So I know it's kind of complex. You know, if we're going to use, you know, they might decide, you know, someone might have done a lot of, been a really bad employee, but also been let go because they have a physical disability, right? Might have been one of the reasons they let them go. So the Human Rights Tribunal only needs to know that was part of the reason that they let them go. It doesn't have to be the only reason, so they're not going to make the same decision as, you know, a small claims to Supreme Court would, where they say, yeah, that person was actually wrongfully dismissed. They didn't have a basis for it. So it's just kind of different avenues about different kind of venues that you're going to want to be aware of.
I'm just going to add a couple of things to that. I have some experience with human rights issues arising in landlord-tenant relationships that I just wanted to mention. That can be a very difficult situation to deal with because, as we've already heard, even if you file a human rights complaint, the BC Human Rights Tribunal works very slowly, whereas most landlord-tenant problems take place on a very short timeline if you're facing eviction, for example. I had a case not long ago where the landlord tried to evict a tenant due to some noise complaints about them. And we had very good evidence from the tenant's doctor that the noise the tenant was creating was because of a condition that affected their mood, but also affected their ability to control the volume of their voice. So it was very clear that the noise they were creating was a function of their disability, and the landlord knew that. And so we made arguments that the landlord had some responsibility to try to accommodate the tenant. And ultimately, we were able to negotiate a resolution with the landlord. But if the landlord had pressed ahead with the attempt to evict the tenant, I am not confident that the RTB would have cared about my medical evidence. I think there's a real chance they would have said, well, you know, this is an unfortunate situation. It's too bad for this tenant, but the fact is they're causing too much noise and they're disrupting and interfering with other tenants. And therefore, according to the rules that the RTB has to follow, they're allowed to be evicted. So I find it's in some ways, it's a very frustrating thing that the RTB cannot apply the Human Rights Code. And it means that in many cases where a human rights issue comes up in a landlord-tenant situation, you're going to have to be very creative about seeking a remedy. And in some cases, I mean, unfortunately, you might have to tell the client that even though there's a real human rights issue here, it might not help them. And it might not make a difference to the outcome of their RTB case. I also want to add just about any situation where a person thinks that they've been fired for discriminatory reasons, or in any case where they say they shouldn't have been fired, I'm going to say the best advice you can give them as an advocate, almost every case, is that they really should need to get legal advice. Any employment law issue can be very complicated. The stakes can be very high. And, you know, as Odette said, it is certainly, there's different ways to challenge a termination or a firing, depending on what the reasons are. But the human rights process might not always be the best way to go about that, either in terms of timeline or in terms of what the outcome is going to be. And so I think it's employment situations in particular where I would almost always recommend that a client should get legal advice from a lawyer before deciding whether to go to a human rights tribunal or a court or some other process.
There is a comment and question in the chat box. My understanding is that labor arbitrators can also hear HR matters that are related to the grievance. Is this no longer the case?
So I don't have a lot of expertise on labor law, but I believe that's right, that in the labor arbitration that I'm in a unionized workplace, I believe arbitrators do have the power to hear and make decisions about human rights matters. My understanding is that they don't have exclusive jurisdiction to do that. In other words, although a human rights case can be addressed by a labor arbitrator under a collective agreement, it is still possible for a unionized employee on their own to make a complaint to the Human Rights Tribunal. I think I would never recommend someone do that unless they at least first talk to their union. And maybe the union's not going to be supportive. I mean, that's going to depend. Every case is going to be a little different. But I would always recommend that if someone in a unionized workplace has a human rights issue, it's always a good idea to talk to the union about it before making any further decisions.
And I'm just going to go a little bit into that of how you would choose which venue to go with, right? Because and we'll go through some of that, and some of that is based on what remedies you might want to see.
There's another one. Can Canadian Human Rights Commission also help figure out whether a matter is under federal or provincial law?
I think we did discuss that one a few minutes ago.
Yeah, so it can, but what you're going to have to realize is they may not get back to you in time. That's really what you need to be aware of. You can file something, and getting that approval from the Canadian Human Rights Commission, but by the time they get back to you, you might have passed. If they come back to you and they say, this is a provincial jurisdiction, you filed in the wrong jurisdiction, and that year has passed, you can't then, you're going to have difficulty filing that here in BC. So that's why we're just warning you is that, yes, both the Human Rights Tribunal and the BC Human Rights Tribunal and the Canadian Human Rights Commission can give you that information. You may not get it in time. So you really kind of want to assess that beforehand. So like I said, in my case where I filed in one and then they're like, well, really, this should be in the Canadian, and we filed in the Canadian's like, well, maybe this should be in the provincial. And like I said, it's a very nuanced one. You wouldn't normally have that. Neither one has actually given an answer on that. They're just making it aware that we may have that issue, right? Because they want to make sure we're not missing any of those timelines, because the timelines are pretty short. Right? It's just, BC Human Rights Tribunal used to be 6 months. So, it's a very short period of time, and it sounds like it's not, but by the time someone really wraps their mind around it and you get things filed and you get into there and you get a response from from the tribunal or their commission, you may have already passed that deadline.
There's another comment in the chat box about the subsidized rent housing development in their community was very open that they only accepted applications from working people. We saw this as a violation of the code in that it was discriminating against people who receive disability income. I lost it. Receive disability income assistance, but who did not work. We voiced this concern. The building is now full. Our community has had 0 vacancy rates for years. At this point, is there any way to raise this issue? Wouldn't an individual applicant have to demonstrate that her or his application was denied because of the source of income?
So, I'm always going to say as a lawyer, it depends with the situation. I'm not going to say that someone can, but there is only a year for that limitation. So, if it's been over a year since someone's kind of applied for that, you may have an issue there. That's something you need to be aware of. that is something, you could talk to the BC Human Rights Commission about, because it's more of a systemic issue that they could talk about. But from the information that you're giving us, it does sound like that would be a violation of the BC Human Rights Code, because it is based on source of income. There's always, and just to be aware that there are situations where, and I don't think this is the case here, but you just need to be aware that a little more complex. For example, as an employer, you can ask for almost like an exception where you're allowed to be biased. For example, if you wanted to hire, if you're an Indigenous organization, you wanted to hire someone specifically Indigenous or give preference to someone who's Indigenous, you can ask for that. And I can't think of the process right now. Maybe you know better, Andrew. But you can ask for that, and you'll actually see that in the employment ads where they say, we have permission to give preference to somebody who's Indigenous. So there, it's the same way with housing. So you're talking about housing, and we talk about age discrimination. You are allowed to discriminate based on age for places that are only renting to 55 and above. So there's always those little exceptions in there, but just without kind of an exception like that, it does sound that it's based on that, and it's really going to depend on when did this arise and has the year passed. If that makes sense.
So our next couple of slides are about factors you can consider. So the slide you see here says, how do you know which venue? In other words, where to go if you think there's been a human rights problem and you want to address it. So some of the factors to consider are what outcomes you want. In other words, for example, are you looking for just getting some financial compensation, or do you want to see that the person or the organization that violated human rights changes their policy so the same thing doesn't happen again? As Odette said before, if you go to court, for example, in a wrongful dismissal case, you might well get some financial compensation, but the judge is not going to tell the employer, here's what you must do in the future in order to avoid a situation like this again. Other factors to consider are how strong the claim is, how long it might take to get a result, and how much it would cost to bring the case in different venues. We've already talked about how long the Human Rights Tribunal process is here in BC right now. Some other processes might be quicker. For example, going to the Civil Resolution Tribunal or to small claims. And I'm not saying necessarily those are fast processes, but at this stage, for now at least, they are, I think, quite a bit faster than BC's human rights complaint process. There's definitely, in many cases, there's going to be different costs to bringing claims in different venues. Most of the time, if you're going to court, you have to pay a filing fee. Of course, it is possible to be excused from paying the filing fee in some situations, but that compares to, for example, the Human Rights Tribunal, where you don't have to pay a fee to start the process, that anyone can start the process anytime and then without paying a fee. I'm going to go back and just underline, all these are important factors to consider and important factors to discuss if you have a client who believes that they've been discriminated against and wants to try to find some remedy, wants to find a solution to that. These are important points to discuss. I'm still going to say at the end of this, especially if it's an employment situation, go get legal advice, go talk to a lawyer. This is a lot of pressure to be putting on legal advocates who I know are not formally trained or not beyond some of the training like we're doing right now in some of these issues. And as we said right from the start, these are complicated legal issues. And in some cases, the stakes can be very high. So these are some important factors to consider, but I would not necessarily recommend that this discussion is just between you and your client. I think you might want to get some other professionals involved in it as well.
So the next, sorry about spelling mistakes on this, but can you do two venues at the same time? The short answer is yes, but it depends, right? It's going to depend which venue. It's going to depend, on numerous different things. And so oh, sorry, it went the wrong way. What do you want to consider? So, are there separate issues? So as I was discussing it before, is really, are you going to one venue for one issue and another venue for a different issue? That might be a reason why you might do both. And I'm going to go back to what Andrew's been saying throughout. I mean, if you're really debating about two venues, you really should be talking to your supervising lawyer. You really should be getting some legal advice, because it really is a complex issue to be doing both. But you need to be aware and to consider that if you do that, either process can be postponed, so it just might be delayed. So if you've started a human rights claim and at the tribunal and you're going forward with it, and then you filed something in Supreme Court for employment, the Human Rights Tribunal may decide to not do anything further. So they might not even do a mediation. They might not do anything. They might be like, nope, we're going to put this on hold until this other one has been decided. It can also go the other way as well. Generally, my experience, it's been the Human Rights Tribunal that kind of defers and waits, but that's not necessarily the way. Then when the other claim is finished, the Human Rights Tribunal may decide whether they're going to continue with the claim or they're going to dismiss the claim. Now, one of the things I'm going to point out when you're dealing with two venues, especially in tenancies. So I've actually had situations where, there might be a human rights complaint. Now, it may not feel like that to a lot of the advocates, but generally, the residential tenancy branch is fairly quick compared to the Human Rights Tribunal. So you may have, I had a situation where, we filed a human rights complaint based on disability, and then the landlord evicted the tenant. Right. So that was a retaliation against the tenant for filing the Human Rights Tribunal. So that's another thing you can do in the human rights. We filed an allegation, but at the same time, we still have to deal with that eviction. So if your client has been evicted, the first thing you're going to do is you've got to get in there and file, that disputing the eviction. And the odds are that dispute at the residential tenancy branch is going to be dealt with way before you get into the Human Rights Tribunal issues, before that process really starts going. So just be, and even if that's all settled, and like Andrew said, is the residential tenancy branch really doesn't deal with the human rights issues well, so you may have that, and they may get evicted, but the Human Rights Tribunal may decide to continue and say that eviction still was a violation of the Human Rights Code. So that would be a situation where I think generally you would have both venues going at the same time, and it wouldn't cause an issue. On that employment end, that's where you're really going to end up into that issues, and you're really going to want to be careful. Generally, in employment law, you're going to choose one or the other. And that's why you really need to talk to a lawyer or a supervising lawyer, because they're going to really know which venue to go in. And once again, we're talking about the consideration of which venue. It's going to depend on what outcomes are you looking at. For example, if you have an employment thing and you got new employment right away, then going in, the Supreme Court or small claims for wrongful dismissal, you've already got another job that's going to really lower your damages on that. So you might go Human Rights Tribunal, because you're going to get an award based on the Human Rights Tribunal kind of the violation of the Human Rights Code that you wouldn't necessarily get if you were going through Supreme Court. And because you got a job, you really don't have that wrongful dismissal claim. I know that's kind of getting more into the nuances of things, but I just kind of wanted to make that aware that yes, you can do both at the same time, but you're going to want to be really careful when you're doing that. And I think the best time you're going to see that is in that residential tenancy issue.
I wanted to say, I see a question from Jenna in the chat, which I want to address in a second, but Odette, another situation where I think having two separate venues going at the same time, the example I think you gave earlier about you have a case that's you've started in both the federal and the provincial Human Rights Tribunal, I think that makes a lot of sense too. I mean, it's because if you had waited to get a decision from one tribunal about whether they can take the case, by the time they make a decision, if they say, no, we're not going to take it, you're almost definitely too late to start it at the other venue. And so sometimes in a situation like that, you might have to start claims in two venues just to, I think we would use the term preserve your rights, to make sure that you don't lose a deadline, that you don't miss a deadline. And so there's a good chance that one of those cases is going to be dismissed but you don't know which one that's going to be, and you're not going to find out until it's too late to start the other. So in a situation like that, where you're up against a deadline, that might be one reason why you might need to have proceedings going in two different venues at the same time, just as a sort of insurance policy. In case one gets dismissed, you'll still have something going in another scenario. I would still prefer someone to get legal advice about that situation. But if you're up against a deadline, if you know that if you don't file your claim by tomorrow, you're going to lose your chance, that might be a situation where it's worth just going ahead and getting it done, and then getting legal advice as soon as you can. But at least you're not going to lose your right to start the process at all.
That's a great example.
Jenna's question was, and I think Jenna's picking up on, we keep saying, go get legal advice. Jenna's question is, one thing we want to do is be able to give our client a list of things to bring to get advice, I think, from a lawyer to help them get to the main points quicker. And that could be something like a timeline of events, contact information for any witnesses. And Jenna asks, is there anything you'd recommend for us to relay to clients to prepare? And I think she's getting at preparing for an appointment with a lawyer. And I think those are great examples. I mean, as a lawyer, when someone comes into my office and they have, a clear, concise timeline of events, here's what happened and when, and here's the people who are involved in it, and here's how you can contact them. Boy, I'm happy. I'm happy in that situation. That is not what most of my clients do at all. So I agree with Jenna's suggestions about creating a timeline, getting a list of witnesses. The only other thing I would add is if you know that there are any important documents, for example, in a tenancy, that would be probably the lease agreement, any correspondence with the landlord. In an employment situation, that would probably be the employment contract. And again, letters or emails or correspondence with the employer about the firing or the termination or about whatever the issue is. So I think it is a good idea to help your clients prepare for a meeting with a lawyer like that, as Jenna is suggesting. Odette, anything else that we can recommend you bring to an appointment that we would like to have appointments with us?
Besides ID. Right. And I think that timeline is so crucial, especially if you're sending them to a lawyer they're going to have to pay for. A lot of time, I struggle getting timelines out of my clients. So an advocate even being able to sit down and help a client create that timeline is huge. I've had issues where I don't even know when the deadline for the human rights issue is, because the client just is all over the place about their timeline. It's really, really helpful. I would say timelines are extremely helpful. I'm just trying to think about, client solicitor privilege, if they've created the timeline before they go to the lawyer, but I think it would still fall under privilege because you're creating it for the lawyer for litigation purposes. And I'm not going to get into that. There's just things around, what documents you have to disclose to the other side. I think if it's being created for the purposes of a lawyer, it would fall underneath the privilege, so you wouldn't have to worry about that. I think one of the things I think an advocate could also do is just recommending to the client to not talk to people. And don't, one of the problems I find with clients is they, like, for example, if it's a landlord tenant, they keep going at their landlord, and it's like, just stop it, only communicate for what you need to. Don't start just advising them that anything that they say, they should realize it could be before a judge or it could be before a tribunal, in emails and letters, and just making sure that they're aware of that. They need to be polite. They need to not go into other issues, only deal with the issue that they absolutely have to. Try not to sign or agree to anything until you've talked to the lawyer. Because I've had that happen where before they get to myself or another lawyer, they've already come to some kind of agreement or said something that could really detriment their claim, not really realizing what their rights are.
I agree with all that.
And I think we've talked about a lot of times when you should contact a lawyer. That's what your supervising lawyers for. Andrew's really alluded to this. Employment issues, I agree. If you're dealing with employment, you really should be talking to a lawyer. You can, the thing about being an advocate, and I know the Law Foundation, allows, especially with family law, but you can be helping your client even when they have a lawyer, kind of be preparing for that lawyer and stuff like that. and kind of aiding in that kind of issue. But yeah, employment law, I would say, is a really important one. If you're going to be doing that double venue, you should be talking to a lawyer. If you're really starting to ask a lot of questions, you know, you're really unsure about things, that's really when you should be contacting a lawyer. I would say kind of those newer beginner advocates are probably going to have to talk to their supervising lawyer or another lawyer quicker than I would say maybe more senior advocates, but just to kind of be aware of it. And I'm sure, Andrew, you have more examples of when they should be talking to a lawyer.
You know, this is sort of this is easy for me to say. I mean, you should always get it. I mean, you're talking about human rights complaints, you should always get advice from a lawyer. That's easy for me to say. I know it's in practice, it's not always that simple. But I think that we've tried to highlight the situations where it shouldn't even be a question, right? I mean, if it's an employment situation, if someone's been fired and they want to challenge that firing, or they think it was wrongful in any way, they need to be talking to a lawyer who has experience in that type of case. If there's any doubt about which law applies, going back to the jurisdiction question, right? If there's any doubt about whether you're under the federal jurisdiction or provincial jurisdiction, that is something where one little mistake can potentially have serious consequences. And one of the reasons I think why we're saying, I mean, I think probably a main reason why we're saying that you should talk to a lawyer is, I mean, obviously lawyers make mistakes too. Just because your client goes and sees a lawyer, that doesn't mean necessarily they're going to get the correct advice. I mean, hopefully they are. But it's part of covering your butt. You don't want to be giving advice that you're not qualified to give. If a lawyer gives someone bad advice and the person suffers as a result of it, if they lose their claim because they got bad advice from a lawyer, that person can sue that lawyer. And maybe they should in a lot of situations. Obviously, I don't know of that ever happening to a legal advocate. I could be wrong about that. Obviously, we don't want to take a chance of anything like that happening. So if there's any doubt, if it looks like a complex legal issue in any way, and it's always a good idea to talk to a lawyer. The other big area where I would say that legal advice is important is if you're taking on, if the human rights complaint or any kind of legal step that's being considered is against any kind of government agency or government department or any big organization. I mean, there's certain organizations, I'm thinking particularly about the government, but a lot of big corporations too, that if you take any legal steps against them, they're going to come out firing. They're going to hire, big time expensive lawyers and come at you with everything they got, because they are just not going to tolerate, not tolerate is not the right way to put it, but they are going to take, they're going to exercise all the legal rights they have in an attempt to stop that complaint from going forward.
Like big box stores. I've run into that, the big box stores, they'll come at you with everything they got. Yeah.
And so, I mean, in most cases, the worst case scenario there is, well, your client loses their complaint, and that's unfortunate and life goes on. But we know that these situations can be very high stakes for our clients. In some cases, now this wouldn't apply in the Human Rights Tribunal generally. But if you're talking about going to court, if a person goes to court and loses, there is a very good chance that they're going to end up being required to pay some of the other side's legal fees. And especially if the other side has, hired big time expensive lawyers, it's possible those legal fees could be pretty high. So whenever there's any kind of risk like that, or if you're just taking on any respondent with, let's say, deep pockets with a lot of resources, I would not be recommending that a legal advocate try to do that on their own. I do believe there's a lot of lawyers, including myself, who'd be really interested in hearing about that. If you think you've got a good case against, let's say, a government department or a government agency or a big corporation, to me, that's interesting. I'd like to hear about that. I can't speak for all your supervising lawyers, but I bet in a lot of cases they'd be happy to talk to you about those interesting issues and those potentially big deal, high profile kind of cases.
And I'm going to say, when you really start getting into, once you've kind of filed that complaint and you start getting into applications to dismiss, which you'll learn about in your next session, really you should be involving a lawyer in that, though it can be quite complex trying to, make submissions against an application to dismiss. So, you're really going to want to start involving a lawyer when you, especially because it's written. right? It's not like you're helping them out at a trial, but those kind of written arguments, I think are, you're really going to want to kind of be involving some kind of lawyer in that process. And then I think we can take a minute if anyone has any kind of questions, and then we have some scenarios. We're going to break you out into different breakout groups, and then we have scenarios. We're going to give each person a scenario. We'll give you about maybe 10 minutes to look over the scenarios and come up with, just from what we've talked about, how you think that applies to your scenario. And then we'll come back and we'll discuss each one of those scenarios. So unless anyone has any kind of questions, then we'll kind of go on to the scenario situations.
So I see Jen has asked whether director's orders from BC tribunals do not specifically exhaust other claims unless accepted as a form of mediation. For example, employment standards, residential tenancies, employment assistance, and the WCAT, or the Workers' Compensation Appeal Tribunal. And I don't know. I can't say I know the answer to this off the top of my head. I think what Jen is getting at is, if you go to one tribunal and you get a decision on a certain issue, is it then too late to address that same question at a different tribunal? And that could, potentially that's a legal question getting into an issue we call estoppel, which I barely understand myself, and I'm certainly not going to try to explain it here. I think my comment in general would be, just because one tribunal has made a decision about a case, that doesn't necessarily stop another tribunal from making a different decision, but that gets complicated if they are making a decision about the same exact issue. That's where this estoppel problem happens.
So I'm going to use like employment law. So you might go to the Human Rights Tribunal about employment thing, and they might say there was discrimination, right? And they might order, let's say the Human Rights Tribunal ordered some kind of remedy around that, right? Unless you've signed that kind of mediation agreement says you dismiss all other claims. But let's say you get a decision there, you got $20,000 for this. That doesn't necessarily, it may not prohibit you from then making a claim in small claims for lost wages, right? Notice in lieu. However, the courts may take that amount that you got the human rights into consideration when they're giving the remedy in small claims, for example, or the courts may say, no, that was completely dealt with. So it's not a straight answer, because it's going to depend. It's going to depend, what was the actual decision made at the one tribunal? Did it deal with the issues that you're actually talking about? So if the Human Rights Tribunal talks about the wrongful dismissal or something like that, then it may prohibit you, but it's not necessarily going to. What I would say is, what you're more likely to run into is that you've run out of limitation. You've passed that limitation period. By the time you get a decision from the Human Rights Tribunal, the odds are you're past that 2-year limitation. I hate to say that, but it does take a long time to kind of get through the Human Rights Tribunal process. So you're not starting it, the limitation period doesn't start when that decision from the Human Rights Tribunal comes down, or from the small claims comes down. Neither one of those processes is likely to give you a decision in a year. You may be lucky to have that happen, but you're really going to still have to watch on that limitation. And it's really going to depend on how the judge views the decision that was made by the other venue. And what the other venue kind of put into their decision, what issues were before the other venue. So there could be another issue. The Human Employment Standards Act is usually pretty quick in getting their remedies. So you would likely already have that. For example, you can do the Employment Standards Act and make a claim for wrongful dismissal. What they just do is just minus whatever you got through the Employment Standards Act from whatever claim they would have given you for the wrongful dismissal. So, I know that might sound more complicated, but that's kind of what's happening there. So that's why we can't give a straight answer, because it's really going to depend on each individual situation and how the tribunal handled it and what was before the different venues when they made the decision. Here's some resources that you can use. Always your supervising lawyer. Hopefully they know kind of the area of law. There's PovNet, which I know a lot of you use. Access Pro Bono. We have the website there. Class has a human rights clinic. They can be very useful. Sometimes they're quite busy. Disability Alliance BC, that's who Robb's with. I mean, I've called Robb many times, several times on issues. And of course, myself at the Elizabeth Fry Legal Clinic. There's also other legal clinics throughout BC. I know that, my clinic was founded when they opened up 7 clinics throughout BC, numerous of them specialized, and then ones that were more regional, like myself. So we have one in Kelowna. The Kelowna one is with us. It's Elizabeth Fry Legal Clinic as well. So we service both Kamloops and Kelowna. There's one in Prince George. There's one in Victoria. There's a clinic in Surrey, and then there's various other clinics. There's student clinics out there as well. One that can be very helpful is the Indigenous Legal Clinic as well. So if you go on to the Law Foundation has a list of all these clinics on their website. So they're a great resource to look at. And then there's also the Forever the Lawyer referral number, which at least gets the clients in touch with lawyers that specialize in the area that they're dealing with. And as we were saying, when you're dealing with those multiple venues, that's something that you want to be aware of. Now, we uploaded these slides, so don't feel like you have to write down these all quickly. It is there on Sketch, so you can download them as well. I'll stay a little longer. I'm sure Andrew would be able to as well for answering questions.